Hi, and welcome everyone to Is That Even Constitutional? This is a show where we use the lens of the Constitution to dissect current events selected from recent administration actions at the federal level, from headlines, listener questions, or just interesting legal issues that we figure out for ourselves. My name is Sadhana Devaraja, and I am not a constitutional scholar, but lucky for me, my friend Ken Thomas is. Hi, Ken. How are you?
Hey, Sadhana. How are you?
I am doing all right. If you've been following along, you know Ken has been a legislative attorney at the Congressional Research Service for over 30 years of his career. And we are now able to chat with him about some of the things happening today and whether they're constitutional or not. Today, we're going to be talking about diversity, equity, and inclusion, and some of the executive orders and other actions that have been affecting DEI. So maybe just to get us started, wondering what DEI is, diversity, equity, inclusion. What's the definition that we have for DEI? Ken, do you know that? Because I don't.
That's such a great question, Sadhana. So, DEI, which of course stands for diversity, equity, and inclusion, is actually a term that has no legal definition. As we've seen recently, there have been executive orders and other executive actions that have used the term DEI but have not defined them. There is no federal law definition. There is no state law definition. There is no agreed upon definition of what the term DEI means. Now, as we can explore a little more as we go forward, DEI probably is a collection of really a number of different legal ideas and a number of different legal and perhaps even cultural and social ideas that are mostly centered around the idea that minorities in our society have been discriminated against in the past, are discriminated against today, and that there is a desire to help those minorities move more fully into our economy and into our society. How that is happening and what are the appropriate ways to do that are certainly policy questions, but the term DEI itself is not really a precise enough term so that you can just say DEI and then start talking about whether or not DEI is a good or a bad thing. So the real answer to your question is DEI seems to be in the eyes of the beholder.
I love that it's in the eyes of the beholder. And, you know, as someone that is, I work in health equity and in spaces where we may work with folks who are in diversity, equity, and inclusion. And this kind of DEI boogeyman has become a little bit of a meme, right? Because there is no definition, but kind of just used as a way to say, oh, we don't like what's happening here. And what we know is that it can help prevent discrimination. We know that it can make repair harms for people who have been harmed by societal practices and policies over years. And so in practice, it's provided a great benefit, and still recognizing that there isn't, one definition for it, even in the ways that we practice it and the ways that we see it come up in organizations that I work with. And so can you tell us a little bit more about what this means in the education space specifically? What's happening within education related to DEI?
Well, to talk about education, I think what we need to do is we need to maybe set the stage for where we are historically with essentially discrimination in the legal sense in education and even more broadly. So I was at the Department of Education Office for Civil Rights 40 years ago, and we were engaged in DEI. But the legal context we were engaged in DEI back then was actually quite different than we would be today. Back then, the Office for Civil Rights had been engaged in litigation against the Southern universities public universities principally, who had been segregated by law, by statute, and sometimes by the state constitutions. And so these were segregated universities. They were sued under the Civil Rights Act and under the Equal Protection Clause, and consequently, they had settled, and so they were under a court order to desegregate. And so I was part of a task force where we were setting up the procedures that would go into desegregating those schools. And so we were engaged in what today would be called DEI. So, an example I like to use of DEI back then was that we would get data from the schools as to, for instance, how many African American students were attending the white schools, which at that point were very few. And we would look at what procedures the schools were undertaking in order to increase the African American students. So, one of those parameters would be how many African American professors were there. The idea being if there were African American professors, that would make it more likely African American students would feel comfortable with the schools. And so we would look at that data, and then the schools would be encouraged to hire African American professors. And one way that they might do that is they might go to recruiting fairs where African American professors or African Americans who had PhDs in relevant fields would be looking for work, and then the schools would go there and recruit. And that would be something that they would do under the settlement agreement, and then they would report back to us as to their hiring practices and how they're doing. And then if were not hitting certain minority hiring goals, then they would have to basically go back next year and keep doing this kind of thing. So that was DEI practice in the context of a court order intentionally to remedy intentional desegregation. So that is essentially DEI to deal with intentional desegregation under a court order. That is one type of DEI, and that is constitutionally and statutorily mandated DEI.
So, you're saying it's constitutionally mandated. Kind of under what part of the Constitution?
Sorry, that would be the Equal Protection Clause of the Constitution as it relates to public universities. If it was private universities, it would be the Civil Rights Act of 1964 for race, or possibly other Civil Rights Act, depending on what the discrimination was. So that would be one type of DEI. And then other types of DEI that have been relevant in the education space have been something we most often refer to as affirmative action. And that is where, even though there is no specific finding of intentional discrimination by a particular school in a particular case, schools have voluntarily taken steps to admit students of minority because there is a societal form of discrimination, and the schools want to make up for that. And that's something we particularly see at the Ivy Leagues, where they will give extra points to students because they are minority students when they're looking for admissions to their school. Now, affirmative action, there's a lot of litigation surrounding it. There was a case, the Bakke case, which held that a diversity rationale, meaning the idea that diversity in in education was served everybody's purposes by having the benefits of diversity serve everybody, was sufficient to allow to overcome concerns that giving minorities a leg up in admissions was some way discriminating against white. So affirmative actions was allowed for many years in the education space. Only recently was affirmative action in education struck down in the Students for Fair Admission case, which was brought against Harvard University. So now the Supreme Court has held that affirmative action in the education space is is now illegal under the Civil Rights Act, or for public universities under the Equal Protection Clause. And so that is something that the schools have already been dealing with. And in addition, now the Department of Education has taken a more aggressive stance and has indicated that there are further steps that schools might have to take in order to comply with what the Office for Civil Rights is saying are steps to comply with um, essentially the Civil Rights Act regarding other things that might go on campus that would be seen as affirmative action. And principally, those are things such as segregated housing for minorities, segregated clubs, segregated social events, things along those lines. So essentially, the Office of Civil Rights is taking the Fair Admissions Act case, and they are aggressively moving forward to suggest there are other contexts in the education space where they're going to basically move forward and enforce a more aggressive view of what that case means in other aspects of campus life.
Yeah, so I know when we've talked about this outside of the show, just you've said affirmative action has been dead for a while because of this recent case that you're talking about, and so now thinking about like student alliances on campus. I was part of South Asian student alliances at my undergrad and at my law school, so those are under threat now. So these places where um, maybe students who were coming from backgrounds where they were kind of shut out of these processes historically, out of these institutions historically, and where we were finding like welcoming environments to share, history and background and kind of ways of being are now considered a threat, and that's where kind of these DEI cuts in federal actions are going to be targeted. Is that right?
Yeah, no, I will say that the real force of these may not be that a group cannot be named or centered around a common interest. It's really going to be more that it cannot be exclusionary. And so, for instance, if there is an Asian interest group, all that probably really has to be done is there cannot be any exclusionary language in who can be in that group. And so, to some extent, it may be more form over function here as to what is or what is not going to be allowed. Certainly, there may be some chilling effect here where schools may overreact to what the Department of Education is suggesting here, but I don't think that we've really seen that in the guidance documents yet. That the idea that you can't have affinity groups, it's more that these affinity groups have to be open to all students, and this is generally going to be true, I would think, for the other concerns too. If there's housing that is something that may be related to an affinity group, as long as it's not actually exclusionary, it is possible that it is not going to be affected by this kind of guidance.
Oh, that's super interesting, because, my experience being in and leading, those organizations, it was never exclusionary. So, by even form or function, it's probably more of the chilling effect. We had folks from different backgrounds in all of the groups that I was in, and I was a participant of other, kind of affinity groups that might not have been a shared identity, but I had some sort of shared background with, and none of them were exclusionary, in language or in their kind of, whatever charter brought them together. So that's interesting. It might not even be a form question really, but just rather this chilling effect.
Yeah, I also think that, as with almost anything, you can probably find anecdotes of exclusionary situations, and it
Mhm.
does not in any way indicate that that was a common thing. And I think that's probably what's going on here, is that there may well be some anecdotes of those situations, and it may not represent at all the majority of these situations.
Oh, and I think, beyond kind of the affinity groups, which we're narrowing in on, there's also, you mentioned housing and then, scholarships. Is that
Hmm.
right? Okay.
Yeah. Yeah, the scholarships is certainly something that is, I think, always been kind of an interesting issue because, again, it probably fell under the protection of the Bakke rationale. If you can have diversity on the college campus, it would make a certain amount of sense that you could have scholarships exclusively for minorities. Now there seems to be a sense that scholarships for minorities would be at risk. And there seems to be a pullback from this. From a number of state attorney generals have pulled back from this. A number of private universities have. I think McDonald's actually had a Hispanic scholarship award that they have now taken away the requirement that the individual be Hispanic, but they left in the requirement that the person in question receiving the scholarship has to have provided service to the Hispanic community. So, again, there may be situations here where it is the actual limitation of a scholarship to an ethnic group or to what we call suspect class groups. Suspect class groups are, in fact, those groups that would be considered discriminatory under the Civil Rights Act, so race, ethnicity, national origin. And so if a scholarship names particular suspect class groups or a particular suspect class groups, that may be a problem, but it may well be that if you are using some kind of description that would be something that would perhaps be more likely to be engaged in by the suspect class group, that might still be okay. So again, it may be that there are not that many situations that this is really going to be have a big effect, but it is certainly the case that if you are directly naming a race or ethnic group as the recipient of a scholarship, that you probably are going to be having to at least evaluate whether or not there is a litigation risk.
Yeah, there are it sounds like there may be ways and kind of workarounds to still get to some X percent of the intent of these scholarships, housing groups, ceremonies, those types of things. And yet there will still be harm in for that remainder percent of the point of these kind of scholarships, housing, and like directed efforts, which is to repair for harms that historically have excluded these communities. And so that's really great to have your take on that. Do you think we could move on to how these orders are affecting businesses? Was there anything on the education um, front that we still need to cover, or do you think we could talk about how it's affecting private businesses?
No, I think education is important because education was really that last donut hole where a lot of affirmative action was still relevant. But now that that's gone, I think we can move to businesses, universities, really anybody but the education context where it is a different scenario because, as I was saying before, we had, or you were indicating too, obviously anti-discrimination laws have always been in play, but affirmative action really has been off the table for quite some time. So, for instance, affirmative action as a way to give advantages to minorities, not because there's been a finding of intentional discrimination, but as a way to bring minorities into fields where they've been underrepresented. That was something that started in the 1960s. The federal government, for instance, tried to get minorities into contracting in the 1960s by reaching out to, kind of small businesses that were minority owned and things like that. And that went along for about 20 years with some success. But then the Supreme Court stepped in late 1980s. Um, in a series of cases, put some very strong restrictions on the ability of governments to engage in that kind of reaching out to minorities and giving preference based on minority status. I mean, again, there are some opportunities to perhaps reach out to entities because they were small businesses or because they were, perhaps coming from certain economic contexts. But reaching out based on minority status was something that the Supreme Court really cut back on significantly long before it was knocked out in the education context. It really was knocked out in the business context, and so really affirmative action has not been that available in the business context generally. And so where are we now? Well, this is, I think, where we're into this, what I would call the third level of DEI, the first one being discrimination, second one being affirmative action, third one being what I would really call equal access. Now, there really is a very it's hard sometimes to draw lines between equal access and affirmative action, mostly because you will see those terms used very interchangeably in a way that I think can be a little misleading. But the idea of equal access is something more along the lines of just reconsidering how you're hiring once people are hired, how you are treating them, what kind of accessibility you're making your workplace. What are the working conditions you have? So, for instance, if you want things to be more accessible to women, maybe you provide flexible benefits in terms of health, in terms of childcare, in terms of flexible hours. If you're concerned about maybe class differences, maybe some people can't afford certain educational degrees, and so you do a little more skill-based hiring rather than degree-based hiring. Maybe in your job announcements, you're a little more sensitive to cultural concerns as to what you're looking for. So there are a lot of things that are not really specifically focused on providing minority as individuals some kind of step up, but just are provided on making the system more amenable to minorities. Obviously this can be, and as I was saying before, DEI has, I think, in some ways morphed from an early focus on perhaps race and ethnicity to the point now where DEI can focus on things such as LGBT, class, immigration status. I've seen DEI defined as considering the individual as, what their individual needs. And so I think there's a whole range of opportunity that really falls into something that is much more about equal access that probably doesn't obviously represent anything that has any implications for civil rights violations. Training, is another example. I don't see anything inherently wrong or inherently that's going to get you in trouble with training. Now, the things that are perhaps in play are actually very similar to what I just talked about in the education context. So the EEOC, the Equal Employment Opportunity Commission, and Department of Justice issued a memorandum which was pretty much explicating what they considered to be civil rights violations going forward in businesses and universities and other private entities. And I should say that the first four things that they identified were remarkably similar to the education context. They were talking about things like affinity groups, saying that you can have affinity groups, but they can't be exclusionary. So if you have a Asian American affinity group in a job context, then you can't not let people in from a particular ethnicity group. And again, these are suspect class affinity groups. If it's a affinity group about cooking, no problem. You can limit it to people who like cooking, but you can't do it if it's based on some kind of ethnic group, some kind of racial group. Or if you have training, you have DEI training, that DEI training can't be different for, you can't basically take one ethnic group and put them in one room and then a different ethnic group and put them in a different room, even if they're getting the same training. Everybody has to be trained together. You can't have a mentoring program that's just for one minority group. That kind of similar thing, which is basically if business does things that might have implications for might even be kind of DEI based. It can't be just set up in such a way as to help just one group over another. So that was the kind of suggestions that they made, which again are similar to what their context they're making for the education. And then they went on to say something further, and that was that they suggested that DEI training, and they said something I think similar in some similar things have been suggested in the education space too. They said DEI training in and of itself might lead to stigmatizing people who are being trained. So, for instance, there's an example of a unsuccessful civil rights case that was brought by a white employer because he was made to read a number of books. I think one of them was on white fragility, and he brought a case saying that that made him feel
Fragile.
made him feel fragile, made him feel discriminated against. And so the interesting thing is that I don't want to say that he had a case. He had a he had a cause of action. His cause of action was hostile workplace, which is in fact a cause of action under Civil Rights Act. But a hostile workplace is a very difficult to bring case. It requires a severe and pervasive series of actions which cause a reasonable person to feel abused or, basically undergo some change of condition in their employment. So we're talking about
Mhm.
not just reading a book.
Yeah,
It
we're
is
talking about
something that
what's
would,
happening with federal workers right now.
well,
So no, I'm just
possibly,
kidding.
exactly right. Well,
Right.
that's possible. So that is something that the EEOC DOJ memo said in a very, very light way. Like, I mean, it was just a couple of paragraphs. Immediately, a bunch of people sued, and then within a very short period of time, DOJ, EEOC, I think EEOC put out another memo saying, oh, by the way, we didn't mean that this violates free speech, because that was the clear problem. Was that what they're suggesting is that any any time you talked about race and the idea that maybe there is some particular groups in this country who you know might be a little more morally responsible for racial problems than other groups, that was going to create a hostile workplace. And so they immediately issued a much more legally reasonable sounding thing saying, that's okay. You're allowed to teach about race.
And this is in the previous context, right? So not in the current context. When you said that the EEOC then put out the memo saying that it doesn't touch free speech, is that in the current context or the case that you're talking about?
They issued a memo and then they issued a update. And I wouldn't say it was update to memo. It was a website facts and questions and answers that one could see as an update to the memo. So
Oh,
they
I
didn't
see.
specifically they didn't go back and redact and update it,
Yeah.
but it was a much more legal sounding document, which seemed to be a refinement of what was said in that previous thing. So in some
Okay.
ways, it means that the EOC DOJ memo really was to some extent not a huge restatement of anything much new in terms of a big leap forward in terms of restatement of law, except for again the idea that they're going to start um, bringing cases if they can find, again, if they can find training programs or affinity groups or groups that are exclusionary, then they'll bring cases again. If those groups even
Yeah.
exist, even if those anecdotes are available, and, they might bring those cases. So
And so, can you talk a little bit about like how this all reaches private businesses? Because I think that's a little bit of a gap. So there's this executive order, then the EEOC and DOJ are issuing a memo, but why do private businesses care? Is it like that they get federal funding, and so then they need to be compliant with what the EEOC? Can you talk a little bit about why this is even reaching private businesses, and especially this like free speech kind of revision?
No, that is a really good question. So, and it's actually a very important question. So, there are two components to civil rights laws. There are components that are based on essentially either the Constitution or, interestingly enough, they're based on, without going too much into the Constitution, they're based on what are considered to be commerce Commerce Clause based powers of Congress, meaning that because businesses engage in commerce, because they are regulated by Congress under that authority, that was the basis for a lot of the early civil rights laws against non-state actors. And so this was one of the early transitions in civil rights laws. First, the federal government got states to stop engaging in discrimination, and then they went after essentially businesses and individuals engaged in commerce. That was the next step. And then the third step was going after individuals who are receiving federal funds. And so this is that individual this is that fairly large group of people who are subject to that aspect of the civil rights laws that are enforced because you're engaged in business. So this is hiring, firing. This is Title VII, which is if you discriminate against somebody in because of their minority status in hiring, that would be a violation of Title VII, not because you receive federal funds, but because you are a business engaged in commerce. If you are a university who discriminates against somebody in the admission of a student into a program, you're actually violating Title IV of the Civil Rights Act, which is that federal recipients of funds cannot receive funding while they are engaged in that kind of discrimination. And the reason that's a very important distinction is that the Department of Justice has shall we say, a limited funds to chase after businesses, whereas the Department of Education has a very, very big stick by saying we can withhold federal funding if you do not engage in if you do not comply with, our interpretation of civil rights law. So sometimes the federal recipients of federal funding feel a little more pressure to kind of get in line with civil rights laws than private actors do. So it's just basically it's two different enforcement regimes. In general, it's the same. It's generally the same requirements. Sometimes there's a little divergence, but it's actually just two different enforcement regimes, and it's enforced by different entities. Now, all federal agencies who give out federal monies have civil rights offices who will have this kind of authority, but it's really Department of Education that tends to get a lot of the attention for this, because that's where obviously a lot of the, not only the racial, but also the Title IX, the gender and sports and that kind of stuff. So that's why we hear more about Department of Education when it comes to the Office for Civil Rights.
What about in the federal government? So, what about folks in the federal government, so civil servants that are holding these roles? You're talking about the Office of Civil Rights and Department of Education. Many of the departments have these Office of Civil Rights, even though education sounds like might have more funding behind it or more teeth behind it. What's happening to those positions? Are they still existing? Have they been wiped out? Are they allowed to be wiped out?
Right. So I will say historically, I actually have some insight into this. So I was in the Office for Civil Rights when it was undergoing a certain amount of scrutiny from the Reagan administration. And so my office went from engaging a lot of litigation to engaging into very little litigation. So it's actually relatively traditional for at least the enforcement part of offices like the Office for Civil Rights to have significant changes in the priorities based on administrations coming in. Now, obviously, with President Trump going in, this is happening, but this is happening with a lot more enthusiasm than perhaps a normal a transition would find. So, prosecutorial discretion is very, very discretionary with new administrations. And so going forward, what they're going to enforce, obviously, they seem to be now moving away from enforcing kind of what the traditional enforcements would be. Sounds like they're going to be enforcing things that are more in the context of reverse discrimination. Um, in terms of DEI generally within the federal government, most DEI within the federal government, diversity officers, um, diversity training, a lot of things within the federal government. Most of that was created by executive order, and consequently, it is amenable to being withdrawn by executive order. So, in general, anything that involves the actual federal workforce and DEI is probably already it's amenable to being withdrawn and terminated by executive order if it has not been already. I know pretty much all the Biden executive orders relating to DEI were withdrawn already, and a lot of things have been done directing it so that within the federal government itself, DEI has probably pretty much ground to a halt. And then, in the context of what's going forward in terms of enforcement, obviously, what enforcement is going forward is going to be with the priorities of the administration. And then, there's obviously too been a focus on um, federal contractors and having federal contractors um, limit what DEI is going to be going on in their federal contracts. Now, there's kind of two branches to federal contracting and DEI. Um, the existing federal contracts that might have any component that is DEI, there is, first of all, um, just going to be the issue of what does the contract say, and I should say contract or grant. So any contract or grant is going to have terms that would address termination, and some of the contracts or grants might not allow for termination, or certainly not allow for termination for change in policy. That is a clause that can show up in a federal government contract, but doesn't have to. And so there may not be a basis for termination of a federal contract. And if it is terminated, then there may be penalties associated with that. And so that really relates to the particular federal grant or contract, and what the specifics are, and then what happens going forward. So that's the federal grants or contracts going forward. The In terms of grants or contracts that have not yet been assigned, that's going to have to do with whether or not the anything that we could call DEI, whatever DEI is in statute or is in an agency's discretion. So, for instance, if there is mandatory money required, for instance, for HHS to send money to the states to provide handicapped persons the ability to vote. To get them to the voting booths and to help them vote, and that's congressional, it's statutory, it's mandatory grants. Then That's a requirement. Congress makes the appropriation. There's a statute called the Impound Control Act that provides that money appropriated by Congress has to be spent. And so there is no discretion on the part of the administration or of HHS to stop that. On the other hand, if there are discretionary grants to do research on the ability of the handicapped to go vote, or of the discretionary grants of the handicapped to engage in a number of life activities, then it's going to be up to the administration to decide what those discretionary grants will be going out for and for what purpose, what they're going to look like. So there certainly is going to be discretion in what that is spent for. They'll have to spend it on something, but what they spend it on, what it looks like, what they call DEI, et cetera, going forward, it's just, that's going to be up to them. So there is a lot of complexity here. There is a lot of discretion. It's really hard to make blanket statements going forward as to what's going to go on with federal contractors. But the one thing that has been litigated is what federal contractors are doing outside of these federal contracts. So one thing
Mm.
federal contractors were concerned about was their websites and their communications and other things that they're doing, which were not specifically being billed to the federal government, but were things that were DEI. And so a lot of federal contractors immediately started scrubbing all of their
Yeah.
websites of anything that looked like DEI, because they were concerned that that would be the basis for termination of their grants. But some contractors sued, saying this is a violation of free speech because we don't know what we are supposed to be doing one way or another. Some of this stuff is clearly free speech because we're not billing it to the federal government, and we can't be punished for engaging in free speech, especially if the language is so vague that we don't even know what we're supposed to be doing to comply with this. And at least one federal court issued a stay saying that this couldn't be enforced against the contracts, but then a court of appeals pretty much put a stay on that injunction, saying it couldn't be enforced. And so we're obviously still in litigation over this. So the whole federal contracting litigation status for existing federal
Yeah.
contracts is still in play.
Yeah, I'm glad you brought that up because and what you brought up earlier about that kind of the ambiguity of the DEI language. And so, how are these calls being made, and how do we know that even for the funding that's coming from the federal government, that what the work is actually kind of a DEI program or a DEI activity? And so that ambiguity makes it hard to operate. And then against that, all of the other work that's not federally funded for these organizations or these businesses that, we don't even know what DEI is because there's no legal definition of it. And there's all this other work that we do that also probably isn't DEI because we don't have the kind of definition for it in the first place, and that chilling effect is real. And so, love that there's this case that's kind of testing that, and we can put links to that as we go. There's also, I think, a phenomenon where we're seeing like states may have different statutes in this area than the federal government does, and so then there's this kind of ambiguity for businesses and other organizations about, well, the federal government is saying that this can't be set aside in this way for these groups of people, but then we have some like state language that requires some protections for folks in our I see like the big sigh from you. And so I don't know if you have any thoughts about like how folks are navigating that, how businesses and organizations are navigating that conflict in state and federal law.
Yeah, no, unfortunately, in some contexts, federal law is because the supremacy clause, the federal law, it trumps state law. But here, what you're really talking about is essentially conflicting laws, meaning that you can choose which one to comply with. It's just because this is related to federal grants and contracts, and so obviously. If one is a condition of federal law and one is a condition of state law, that in theory, you can give up the federal contract. But for some people, that is a
Non-starter. Yeah.
an impossible result. So there are, unfortunately, what used to be kind of interesting legal concerns and questions are now existential crises.
Yeah.
And there are legal questions that never used to come up, or they used to come up in these very particular contexts that are now central. And we don't have answers to them because we never used to have answers to them. And and there used to be political answers to them that are no longer available because different groups of different governments aren't talking to each other. Comedy is no longer available, and we're even having apparently the American embassy just contacted the French businesses who engage in business with the U.S. and said that they have to get rid of all their DEI, or we would stop doing business with them. So now we're not even, we're going extraterritorial with our newly discovered, legal oddities. So this is uncharted territory, and there's really nothing that can be said that really makes sense of it, except for trying to explain it as best we can, and trying to strategize around it.
Yeah. And I will say, like, one um, silver lining that I heard from you is the example that you gave with people with disabilities and voting access. There are certain protections that have been legislated, and those are not kind of able to be swept away through these actions. And I'm sure they're very narrow and, not nearly as broad as we would want to be protective. But it sounds like there are some protections in place, and maybe that's another route for being able to re recommit some of these protections. So
Yeah.
I think we covered what we wanted to today. We talked about, what DEI is, or what we know about what it is or isn't. Kind of went through DEI in education, and then how legal concerns may come up for private businesses, as well as for federal government and contracting. Um, I don't know if there was anything else you wanted to add that we didn't get to cover today.
I think we covered a lot. I think
Yeah.
I can't think of any more I want to talk about.
So thanks so much, Ken. I found this super valuable and interesting, and I'm sure other folks did too. Just want to remind folks to, follow. Is that even constitutional on wherever you get your podcasts? The music today is courtesy of Ken Thomas, and we are looking forward to seeing y'all next time.
Thank you, Sadhana.
Thanks, Ken.